In this issue of the practice, we examine an emerging trend within the legal profession, the role of paraprofessionals. Paraprofessionals are individuals who are licensed to perform some, but not all, duties of traditional lawyers. To help explore this issue and to help contextualize this issue, in the spirit of the practice, we looked at an analogous profession, medicine. We looked at medicine in particular around this paraprofessional issue because medicine has had a long and deep history of using paraprofessionals. Indeed, many of our practice readers will likely have experienced paraprofessionals within medicine. They're often called physician's assistants or nurse practitioners. Paraprofessionals in medicine arose, roughly speaking, after World War II, when there was a huge influx of medics coming back from the war and reintegrating into the American workforce. These medics had deep and vast experience actually performing medicine on the battlefields of Europe and in the Pacific. At the same time, they needed licensing within the United States to perform what they had been doing in wartime. At the same time, there was a lack of doctors, particularly in rural areas of America. So putting these two things together, after World War II, originally at Duke Medical School, physician assistant programs began to arise. These were programs run through medical schools and often and always specifically geared toward producing physician assistants, as they became known as, who were often from this corps of medical and medic from the Army. Over time, this role expanded and grew within medicine, where today there is something like 8,000 physician assistant programs within the United States. These programs are highly competitive. Again, just looking at Duke, which is where this was all founded, the acceptance rate into the physician assistant program is something like less than 2%. There's also state bodies that are regulating physician's assistants, both what they can and what they cannot do, how they are similar, but also how they are different from traditional medical doctors, or MDs. Just to give some examples of what physician's assistants can do, they can, in virtually every state today, prescribe most, though not all, medicines independently. They can, in most states, independently submit insurance and Medicare and Medicaid claims. In other words, bill directly, which was a big change from how it used to be, where only medical doctors could. At the same time, there's things that physician's assistants cannot do, or that they need medical doctors to work with them to accomplish. For instance, there are levels of drugs that physician's assistants cannot prescribe independently. Also, physician's assistants often work in concert with medical doctors in performing their duties. This is often in a practice group or in other hospital or clinical setting. To further help contextualize the role of physician's assistants and how the paraprofessionals were integrated into medicine, the faculty director of the Center on the Legal Profession, Professor David Wilkins, interviewed Dean Mary Klopman, who is the head of and the vice chancellor of the Duke Medical System, again, where physician's assistants initially roll. They talked about how physician's assistants integrate with medical doctors in the 21st century. And in one of the most profound takeaways of the interview, which will be linked below, was Dean Klopman's comment that medicine has really moved beyond classifying people as doctors or physician's assistants or nurse practitioners or nurses, or at least moved beyond the stigmas that being a lesser or greater professional brings. In other words, they think about care in a clinical sense as a team environment in which each of these professional roles has a specific duty to play and a specific responsibility to play. She also commented that the goal is to have each of these various professionals, whether they're medical doctors or physician's assistants, operate at the highest extent of their license. In other words, that medical doctors are operating at the highest extremes of what they're licensed to do. Similarly for physician's assistants, so that the greatest amount of care can be delivered to the greatest amount of individuals. So that's the context, and that's the context in which We then, in the practice, started to apply these lessons from medicine to the legal profession, which is experimenting with paraprofessionals at a much earlier stage. The legal profession is now just beginning to experiment with paraprofessional roles in its ranks. And in particular, the experiments have really begun in Washington State, where recently the state has created what is called the Limited Licensed Legal Technician, or LLT model. In the lead story of the practice, which was written by a Harvard Law School graduate named Becca Donaldson, we explore how LLTs have evolved, their purpose, and how they fit within these wider debates around what does it mean to be a professional in the 21st century. Becca starts her article by acknowledging a fact that many of us know, that there's a significant access to justice gap, both in the United States, but more specifically in Washington State. She does this because part of that gap is driven by the high costs of lawyers. And in particular, there's an assumption that the high costs of lawyers are in part driven by licensing requirements, a long runway to actually become a lawyer. This is 4 years of undergraduate education, 3 years of law school, a bar exam, and then you're licensed to practice law in its entirety. The LLT model, which originates out of the Washington State Bar itself, is an attempt to both create a lower cost model of delivering legal services, while at the same time creating a regulatory framework such that quality is maintained. So what are LLTs? LLTs are, as the name implied, limited licensed legal technicians. They are licensed by the bar, and there are certain requirements by the bar in Washington to perform certain but not all legal services. Currently, it's limited to, for instance, family law. The requirements are quite extensive. For instance, to become a limited licensed legal technician, you need to take a certain number of legal-oriented classes at ABA-accredited law schools. For instance, you have to take civil procedure. You have to take a course on contracts. You have to take a whole host of courses that are designed specifically to train practitioners to become LLTs. Also, like the nurse practitioner model, the physician assistant model, the programs require a level of on-the-ground knowledge or pre-existing knowledge around particular areas. What are LLTs licensed to do? Currently, it's limited to family law. They can talk to clients. They can provide legal advice to clients. They can engage with clients in legal matters relating to family law, just as any traditional lawyer could. What can't they do? They can't, for instance, practice contract law around corporations, or they can't advise on wills or anything like that. They're limited to family law as defined in Washington State. One of the central questions of Becca's article is whether LLTs are actually reducing the cost of legal services. And one of her major findings is, despite that being the goal of when they were instituted, they actually may not be. And she finds this for a number of reasons. One, while there is less education, less time spent at university, and the cost that would entail, LLTs still do have quite stringent university requirements, and there still are loans that need to be paid back, which is producing a knock-on effect in terms of price down the road. Similarly, she found that while LLTs don't have to operate in traditional legal service organizations, they often do, given the complexities of hanging one's shingle and being a solo practitioner. For instance, many LLTs operate within wider law firms staffed by traditional lawyers that include things like rental of office space, technology solutions, malpractice insurance, and all the other types of costs that require them to raise their fees. So what does this mean? On the one hand, it means it's debatable as to whether LLTs are actually lowering the cost of legal services within this limited area, family law, in Washington State. Yet, on the other hand, we do see the model itself, or at least the paraprofessional model itself, expanding to other jurisdictions in the United States. For instance, Utah recently enacted similar regulations producing paraprofessionals. Washington State is considering expanding what triple LTs can actually do beyond family law. We learn from medicine that there can be very good gains provided by paraprofessionals when instituted properly and regulated properly. The challenge for the legal profession is figuring out how paraprofessionals fit with the wider ecosystem of lawyers in this country, and how to both regulate them but also empower them in ways that will help address the access to justice problem. We're going to continue to cover all of these issues in the practice, and we'll report about them to you here.